Hey, everybody. Welcome. I missed you guys last week, but I have lots to share with you. There's lots to talk about. First of all, I have finally gotten my office organized and painted, and I've got a little video I'll show everybody. And so that was my big project this last week, was to get my office in a better situation, and my workstation organized and arranged so the light's better, and so everything seems to be going along. Also, Jen, our world famous and favorite moderator, was in the middle of moving cross country, so she's settled in and doing better, and I think we're back to getting our feet on the ground and things being normal again. So I don't know about you all, but it has been absolutely beautiful in Central Oregon. This is last night's sunset from my living room. My house looks out and really have about almost a 360-degree view, starting with Smith Rock, which is a world-class climbing destination for rock climbing, and then in a full circle around the Cascade Mountains. This is part of the Three Sisters. So we have the view of several mountains right out off our deck. This is actually off my deck. So weather has improved. It was in the 80s today, and I actually got a little time out on my deck. So it was a great day. But I did want to show you, I'm going to share my screen so I can show you what I've been up to. So those of you who've known me a while know that when we moved into this house, this is my office is in an upstairs small extra bedroom, and the interior was painted submarine gray. So yes, that is the caution, beware of the shark. So I painted, it's now kind of a sage green, kind of a pale gray green. That's my favorite area rug. And I have one wall that's a little bit darker green. So just got some things up on the wall finally. Got to have the cat stand up here since my critters are up here a lot. You can still see I haven't got my step stool out. Finally got my diplomas and my law school class picture up. And then a bookcase for a backdrop. So that's what you can see behind me here. And so I will tell you, it is a huge improvement over the Battleship Gray. So I'm relieved to have that all done. So, well, Jen made it from the west to the east. She left California and went to North Carolina. So she is enjoying and very happy in her new place. Those of you who don't know Jen very well, she is a rescuer of special needs dogs. So she's got sweet little puppies that she's had to contend with moving, and that's never simple when you have little pups with special needs, but they made it like champs and everybody's happy. So we have a lot to talk about because we weren't here last week, and we do have a few things to catch up on with Lori Vallow because she is coming up on trial in the end of next week, I believe, her on the 30th. That is Monday, I think. Jury selection starts for her in Brandon Budro's trial. But she's also been filing motions in the trial having to do with Charles Vallow that she's already been convicted in. Now, remember, the judge asked her whether she wanted to be sentenced or not, and she decided no, that she did not want to be sentenced until after the Budro trial. I don't know that it's going to make a whole lot of difference, but she didn't want to be sentenced in Arizona until after Brandon Budro, the trial on on her charges involving him as the victim. So, but she did file a motion for a new trial, and in her usual hyperbolic way, she alleged a whole bunch of things which the prosecution was quick to respond to. So I'm just going to run through those real quick. So her motion for a new trial included that there was juror misconduct, which we know isn't true. Initially, what happened was after the jury rendered their verdict and they were excused, there were people, both bailiffs and other people around the courthouse, who were telling them, oh man, now that you are done, you need to Google this woman. And so they did. And before they ever left the jury room, but after they had rendered their verdict, they Googled Lori on their phones and discovered that she had 3 other convictions and discovered all of the other information about the deaths of Tylee and JJ, and those other issues, all those other convictions. So then they walked out of the courthouse and they were just assaulted with reporters and media. And the media were all sticking cameras in their faces, and they were caught off guard by how intent the interest was. So they, a lot of them were a little put off by it. Some of them declined to talk, but the jurors who did talk, including juror 15, talked about that they had just learned what her earlier convictions were for. However, when juror 15 was asked, he said, well, you know, when I was driving home yesterday and I was thinking about her prior convictions, according to him, he misspoke. He absolutely says that he did not know about her convictions until that day, but he was very thrown off by the fact that by all the media, and kind of taken aback and misspoke. That has been his contention since at the beginning, since the day after the trial. He's given some interviews and he has repeatedly said that. The judge believes that believes the juror, and so the state laid out their response, which was basically no, that there was no misconduct. The second issue was she took issue with the fact that the court precluded the statements of Alex and Tylee coming in as impermissible hearsay without an exception. She contends that there was an exception because for I'd have to look it back up, but she contended there was a hearsay exception, and the one that she cited, this does not fall into. And in fact, it is hearsay. The body cam and the interviews that were recorded with Tylee and Alex are hearsay. Now, I think there is an argument that Alex's could come in as statements of a party opponent. So there is an exception to the hearsay rule that if you are a party to the case and you are pretty much making statements that are against your interest, that those come in. But the judge has consistently found that there is not an exception that applies to that. So the third one was her complaint about discovery violations. Now, she contends that the violation had to do with the cell phone data, Charles Vallow's cell phone data. So the cell phone data, the Cellbrite reports and all of that data were disclosed to the defense, to Lori, on the 9th of January of 2025. Well, it may be 2024. I wrote down 24 here, but that seems like it was a little far away, but it could have been actually 24. So on March 12th of this year, just before the last trial started, she noticed Lonnie Dworkin as an expert witness, and the prosecution objected because they had not had any notice, and the deadline had passed for expert witnesses to be identified and their reports to be produced. Lori complained that it was because even though she put her request in with the state for payment of experts in January, it didn't get approved until March. If you recall, the prosecution objected because they didn't have any notice. If you recall, the judge offered a continuance to Lori so that she could get her experts in line. She did not want a continuance. She declined a continuance and said, I want my speedy trial. I don't want a continuance. And the judge then said, well, then you don't get Lonnie Dworkin because he hasn't completed the work. He hasn't completed the reports, and they haven't been discovered to the prosecution. And there was no evidence during the trial of any exculpatory evidence contained in those cell phone records. The fourth was prosecutorial misconduct. She's still on this, harping on this, that Trina Kay somehow committed misconduct by having contact with Nate Eaton to tell him that that they weren't calling him. The fifth was the court's lack of impartiality. She brought this up at the last hearing, asking the judge to recuse himself because he was not impartial. And that pretty much fell on deaf ears. The judge did say that there was one particular comment, and to be honest, I can't remember what it was now, that he should not have made, that he should have simply sustained the objection and not added a comment. So, but he said that does not mean I'm not impartial. So he has denied completely her motion for a new trial. Now, undoubtedly, she will continue to appeal that up through the appellate process because that's what she does. I'm sure that at this point, she will ask for a court-appointed appellate attorney because she's got her hands full with the next trial, which is the trial on the attempt on the life of Brandon Budro. For those of you who maybe haven't been following the cases, Brandon Budro was the former husband of Lori's niece, Melanie Budro, who is now Pulowski. So in that case, she is filing some pretrial motions. And those motions include a motion to preclude Alex Cox's text messages as hearsay. So on one hand, she's upset that they couldn't bring in his examination and his interview with the police in Charles Vallow's case. But now she says she wants his text messages kept out because they're hearsay. The prosecution, she also says that they were not seized appropriately. And so the prosecution says there was a warrant. It's a statement of a party opponent because he's a co-defendant, even though he's deceased. So we'll see what the judge does with that. I actually think she could have argued that the statement that Alex's statements were the statement of a party opponent in the last trial, but she didn't argue it. So, and that's because she was operating as her own lawyer. So she probably didn't realize that she could do that. The second motion was a motion to suppress the seizure of the Jeep that Tylee's Jeep that Alex was driving. Tylee was already dead, and Alex was driving it when he took the shot at Brandon Budro. So she wants that suppressed. She says that it was an illegal search. So what happened was that Ray Hermosillo, who was the lead detective in Rexburg from the Rexburg PD, initially was contacted by Gilbert or Chandler, I guess it was. No, I don't know. Gilbert and Chandler are two suburban areas that kind of run together outside of Phoenix. And Lori's house, I believe, was in Chandler, and but Brandon's house was in Gilbert. So both police agencies were involved. I'm not sure which one got in touch with Rexburg because they knew Lori was there and asked Rexburg for surveillance on the Jeep because they knew the Jeep was there, or they suspected it was there. So Hermosillo had been looking for the Jeep, and one day when he was leaving the gym on his way to work, he spotted the Jeep in Lori's parking lot. And so he contacted Arizona, and they said, impound it and hold it while we get a warrant. Well, because it's interstate, it took them a week plus to get the warrant and to send somebody from Arizona to execute the warrant. So during that time, they held that in impound. And it is legal to do that because a vehicle's mobile and can be hidden or can be can disappear. And so it is legal to impound a vehicle while you wait for a warrant. You can't search the vehicle. It has to remain sealed, but you can hold it. So she's wrong on the law on this one. They followed the law. Hermosillo said, Arizona said they had probable cause, and they sent a probable cause affidavit that justified the impound to Rexburg, to the Rexburg PD, and then they held it until Arizona showed up with their warrant. So she's not going to win that one. She's I doubt going to win the keeping Alex Cox's text messages out. The last one is a motion to dismiss the entire case for non-preservation of evidence. And the evidence she's upset that they didn't preserve was Brandon Budro's car door. And so the prosecution says the car door is not exculpatory evidence. We were not required to keep it. And there's plenty of pictures and all the other appropriate stuff to preserve the scene. We didn't need the car door. So I doubt seriously she wins that one either. But she does, I'm sure will be at least one more pretrial hearing before their trial starts and jury selection starts. So, and then we're back to the circus again with her representing herself. So, the next case I wanted to talk about is Crystal Rogers. This is a case out of Kentucky. The victim's name is Crystal Rogers. The people who are on trial for her murder are Brooks Houck and Joseph Lawson. Joseph Lawson's father is, I think that's right, is also, there's a father and a son, Larson. And one of them is a co-defendant with Brooks Houck, and the other one is being prosecuted individually on a separate case. The trial is going on now. They picked a jury, and today was the second day of testimony. There is no live feed, just some really, really bad court sketches. I mean, you thought the ones from Vallow were bad? Yeesh, these are terrible. Anyway, the only ones worse might be the ones from P. Diddy, but if you're not familiar with this case, it's a case out of Kentucky. Crystal Rogers and Brooks Houck were dating. They'd been in a long-term relationship, and she went missing almost 10 years ago. Her body has never been found. For several years after, her father was searching for her remains. He believed for a very long time that Brooks Houck was responsible for Crystal's disappearance and that she was deceased. And a year after Crystal's death, he was out searching out in rural areas when he was shot and killed. And his death remains unsolved. So that one is going on. I'm going to do my best to cover it, although there's not a lot of information coming out because it's not being live streamed. And I think that in Kentucky, it's a pretty high profile case, but to be honest, I think outside of Kentucky, it may not be as, there might not be as much interest in it. So I decided a little cold white wine sounded like a good treat tonight. So let's talk about Bryan Kohberger, because there's a lot of stuff going on in that case. The defense has moved for a continuance. Now, I want to say this case for Ada County is like the 900-pound gorilla that sits anywhere it wants. I mean, it's a huge undertaking. We saw this in the same courthouse for Vallow and then Daybell. And Kohberger, I really think, will be even bigger, and there will be even more interest in the Kohberger case. And So it's a very unwieldy situation because right now they're talking about jury selection starting on the 11th of July, and they have the entire year until the first part of November blocked out for this trial. So it could go that long. That's really tough for juries to keep juries. I'm sure that they're going to pack as many alternates as they can in because it's going to be such a prolonged, protracted jury. And then, so the logistics for the courthouse, they during Vallow Daybell, they had to set up a reservation system as to whether or not you could be in the courtroom or you could be in a large overflow room with closed circuit TV. Now, as far as we know, this trial is going to be live streamed, so that is going to take some of the pressure off the courthouse. But still, it's going to take up the biggest courthouse in the the biggest courtroom in the courthouse for months. And so it's going to be a big undertaking for Ada County. So now the defense is saying they want a continuance. They want to continue the case partly because of some recent releases of a Dateline episode, and partly because they're not done with their mitigation case. So I think it's possible this judge may feel like he doesn't have any other choice but to continue the case. I could also see it being possible the judge saying, this case is so difficult to schedule that I'm not going to reschedule it. I'm going to require that you go forward. The case has been pending for quite a while, and it is not as if the defense hasn't had time to file lots and lots of motions and all of those things. So, but the biggest issue right now is that there was 2 weeks ago, a Dateline episode that came out. It was the third time Dateline has covered the Kohberger case. And this one included information that neither side believes should have been released. There have been bits and pieces of information that have dribbled out because they've been included in motions and in filings that were not sealed. And this judge, Judge Hippler, has been very hesitant to seal pleadings. So he has not been really open to the idea of lots of sealed documents the way that they were in the Vallow case. However, there is a gag order, and the gag order applies to both the prosecution and the defense, as well as any other people involved in the case, law enforcement, investigators, experts, any of those folks. So many people believe that somebody talked to Dateline because they had information that has not been made public, that did not come out in filings. And so Ann Taylor, Bryan Kohberger's attorney, doesn't believe, believes that that information is going to further prejudice a jury pool. So she's asking for a continuance because of that. The judge has ordered that everyone, defense and prosecution, all the law enforcement, all the experts, all of the investigators, anybody who is involved in the case, preserve all of their texts and emails and any communication associated with the case indefinitely. And the judge is also asking to appoint a special prosecutor, so someone outside the prosecutor's office, to investigate whether or not there was a leak. And it appears from just the judge's demeanor and some of the things that he has said that he believes the leak came from the state. And I suppose that makes sense. Nothing, certainly nothing that was leaked would have been beneficial to the defense. So Ann Taylor is now saying they they want a continuance, and they don't believe that they can get a fair trial because of these leaks. And the judge has ordered both sides to preserve all of their communication and await a special prosecutor. So that case could get even more difficult and convoluted. And I think that it's at least 50-50 that the judge may grant that continuance. So we may not see Bryan Kohberger go to trial until 2026. And, what we know is that delay usually works to the benefit of the defense. Memories fade, witnesses disappear. In general, we think that it favors the defense. So, the last update I have before, oh no, I've got two more before we get to the Karen Reed case. The next one is Lindsay Shiver. She is the woman accused of trying to conspire to unalive her now ex-husband in the Bahamas. And it's interesting because her husband is in Georgia, I believe, and she has been living in Alabama with her parents, or the other way around, I can't remember. But she was initially in custody in the Bahamas. She was let out on bail on the condition that she stay in the Bahamas. So she was there for, I don't know, a couple of months, and then they filed a motion for her to be allowed to go live with her parents in the US while she was awaiting trial. She had to be on an ankle monitor, and she had to live at home. Well, she hasn't been, and there was a gag order. So they violated the gag order by showing up for trial with a Dateline camera crew, or 2020 camera crew. And so the judge revoked her bail, and she sat in Fox Hill, which we've talked about at length, and it is a horrendous prison. I understand that the women's section is better than the men's, but I wouldn't want to be there. So she was there. She was back in Fox Hill for another 3 months or so, and then she was once again released on bond. The rules once again were that she had to live with her parents until her trial. However, she started seeing a new man. There's some talk that she moved into her own apartment before that, but then she later moved in with this boyfriend. And old Lindsay, her picker's not very effective because she picks them. So she moved out of her parents' house, moved in with the boyfriend. Now she claims that the boyfriend has committed domestic violence with her. He's now in jail. I don't know whether she's back living with her parents or not. She's supposed to be, but she is now the victim, and he is awaiting trial on those new domestic violence charges. In the meantime, her ex, the former NFL football player that she was married to, who is quite wealthy and comes from a very wealthy family, Robert Shiver, well, he's been dating up until recently Savannah Chrisley of Chrisley fame of I can't think of the name of it's something to do with Chrisley's. It's a reality show. And her parents have been in jail for some sort of white collar fraud. And they have been in jail. Todd and I don't know, because these aren't people I follow, so I don't know. But anyway, so she's recently broken up with Robert, and just today, the Chrisleys got a presidential pardon. So that's all about Lindsay Shiver. Now, there's some dirt to dish in the Adelson case. Holy cow. So y'all know Donna Adelson was arrested. She is the queen bee. Her son, oh, Chrisley knows best. Thank you for the Chrisleys. And Savannah is the daughter, and she's the one who is dating Rob Shiver. But they've broken up now, according to tabloid TV. So the Adelsons, Donna Adelson is accused of conspiring with her son, Charlie Adelson, who has already been convicted, using Katie Magbanoa as the intermediary to two gunmen who went from Miami to Tallahassee and killed Donna's former son-in-law, law professor Dan Markell, because he was putting up a fight with his ex-wife, Wendy Adelson, Donna's daughter, when she wanted to move back to Florida. So it has taken almost 10 years to bring everyone to justice so far. The question is, are the last two, Wendy Adelson and Harvey Adelson, Donna's husband, the father of Charlie, Wendy, and Robert, whether they are the next ones to be arrested or not. So y'all know that Charlie Adelson and Donna Adelson, Charlie's a serious mama's boy and used to talk to Donna several times a day. Now that Donna's in Tallahassee and Charlie is in prison, he was recently moved out of Florida State Prison to a different state because of safety concerns. So they are talking frequently. Now, Donna and Charlie have plenty of money, so Harvey can put all kinds of money on. Donna and Harvey have plenty of money, so they can put all kinds of money on Donna's books, and she and Charlie can talk all they want. But the police have been recording these conversations. They discovered that Donna was using a different inmate's PIN number or phone privileges to call Harvey, so they wouldn't be recorded under her name. They were, however, recorded, as well as potentially using the telephone of one of her attorneys. That's another allegation. But here's the most troubling part. The most troubling part is that this new investigation included wiretaps, including with Harvey, that allege that there were witnesses that she and Harvey were scheming to harm their own son, Rob, as well as Katie Magbanawa and the mother of a jailhouse snitch. So they were talking about, to quote one of our YouTubers, unfortunately unalive, those three people. So Donna seems to be a quick study when it comes to being a crime boss. She seems to have sort of taken to the life pretty readily. And, but of course, not being brilliant, she did, poor Harvey ended up being wiretapped while they were conversing about these things. So that one, it started because the state said that they had these new wiretaps, and Donna Adelson's attorneys said, we want to redepose a bunch of people, including Rob Adelson. He is estranged from the family and some other people. And so Donna asked for a postponement and the court granted it. So we don't, the postponement is, I gotta get my court date list out. The judge agreed to postpone it until August 19th, but one wonders whether it will continue, whether they will postpone that date as well, because of these new investigations. It's interesting that the state, Georgia Kappelman, who is the lead prosecutor on the case, has been very methodical about going after these people. They went after the gunman first, and then they went after Katie Magbanawa, who was the go-between, and then they went after Charlie, and now they're going after Donna. And so they're very systematically knocking these down. I suspect that they're going to continue to systematically knock them down. There's been some suggestion out there that some of these wiretaps may also give new information about Wendy. Now, Wendy is up and moved out of Florida and gone to Austin, Texas with her children since Donna was arrested. So we don't really know whether that's true or whether that might just be wishful thinking in the rumor mill, but we will wait to see. So, and now let us turn to the shit show that is the Karen Read trial. I am telling you, the prosecution will very likely rest after the witness that is on the stand right now. And I am dying to see what the defense has up their sleeve, because this case has just been incredible. And it's even more incredible knowing what we know from the first trial. So there's no question that this case has been streamlined from the Lally version, but I'm not convinced that, and I will say that I think that Hank Brennan is a better lawyer than Lally. However, I don't think he's honest. I think he's been underhanded throughout the whole thing. So that undermines his credibility in my mind, at least. So one of the big moments, and I will say, as they have gone through, they started out with the EMT witnesses and the medical people, and they got Jennifer McCabe in, and they got uh, um, Katie. Is it Katie? All these names start to run together. Anyway, they got the two women who were there on the scene. They have not called anybody that was in the house at 34 Fairview. They called Brian Higgins, talked about text messages. No, they didn't call Brian Higgins. They got all the text messages in through Trooper Buchanan, who was the supervisor above Michael Proctor, the disgraced attorney, and our disgraced state trooper. Sorry. So they were able to get all that information in. And then they brought in their technical witnesses, the DNA and all of that stuff. Well, frankly, it has just not been all of that persuasive. The DNA experts said that the hair that they made such a big deal about, the only thing they could do would be to link it to John O'Keefe's matrilineal line. So when you're looking at DNA, if you're looking at mitochondrial DNA, which is what is in the hair shaft, the only thing you can do is say, this hair came from someone in this matrilineal line. They have a common female ancestor. It could be grandmother, it could be great grandmother. So that hair could belong to John O'Keefe. It could also belong to his niece. It could also belong to his mother. It could also belong to his sister. So it's not all that persuasive. So then they brought in the glass expert. Of course, we got we reconstructed the tail light, yada, yada, that we got last time. We got the glass expert. Alan Jackson, defense attorney, did a smart thing. He created a demonstrative piece of evidence, a demonstrative exhibit, and it listed what matched which. And it became very clear very soon that none of that glass that they claimed came from a drinking glass or whatever, none of it matched. None of it really corroborated the story. So then it all came down to the accident reconstructionists. Oh, there were some cell phone experts. So then it all came down to these two accident reconstructionists from Aperture, is the name of the company. The first person was the person who compiled the timeline out of all the cell phone data and all the electronic data, the car telematics and the phones, and he was the one who synthesized all of that information to create a timeline. So last week, just before they were preparing to testify, the state came in and said, oh, we have a new report for you. And this new report, created by this guy named Shannon Burgess, he was the one who put together the timeline based on all the electronics, the car and the phones and all that. And he's changed his timeline. And they changed it. One of the things that has come up is that John O'Keefe's phone locked with a physical someone pushing the lock button after the time that the state has alleged the impact with John O'Keefe happened. Now, the medical examiner has said, and the forensic neurologist has said, the injury to John O'Keefe's head would have been so catastrophic that he would have been rendered basically unable to do anything within seconds. So the timeline has always been that this lock incident where someone physically locked John's phone happened after, yeah, Juliana says, Mr. Mendacity, after the state alleged that the collision had supposedly happened with John O'Keefe. So the defense put up a big stink about it. The judge, because she's the judge from hell, let it in. So the defense has been forced to poke holes in all of this information. So they get Shannon Burgess on, the prosecution gets him on the stand. They go through all of his findings. He claims that he was just double checking his work and he realized this, that it was, the information was really, should be interpreted differently after trial had started. I mean, this is, this is almost to the level of sandbagging as they were last time with producing the reversed Sally Port video at the last trial. Interestingly enough, they didn't offer a lot of that Sally Port video. They did offer some. They offered the pieces that showed Brian Higgins there and talking on his phone when he said he wasn't. And they did offer some of the Sally Port video, but certainly not to the extent that they did in the first trial. So they get Shannon Burgess on the stand, and he's just adamant that no, the new timeline is the right timeline, and that means that the window of the time that that they allege this incident happened based on the car calculations and John O'Keefe's phone overlap. So it might be possible that that he hit the lock phone tiny seconds before the impact. So it's pretty suspicious. And so the next thing that happens is that the defense then, as they're start cross-examining this guy about his educational history, which he has listed in his CV, but has not. Brennan was very careful not to elicit anything about his college education. He elicited about his experience and about his certifications with various things like Cellbrite and some of the platforms that analyze digital data, but he did not touch the guy's education. So then the defense gets up and they say, we have a whole series of your CVs, your resumes, and we have your LinkedIn profile, and we have all of these website links to the company website, and they all say something slightly different about your educational background. One of them says that you have a bachelor of a BS degree in applied mathematics from this University of Alabama somewhere. The next one's, and that happened in 2016. The next one says in 2019, there's one that says that you're currently pursuing a degree, that degree from whatever. the 2024 in 2024, your CV says you have that degree, although you don't, do you? No. You've never had a bachelor's degree. No, I never have. And there's no such degree as the one you claim to have from this university. Well, I was pursuing it. Well, it comes out that he's been pursuing a bachelor's degree for the past 17 years, and he still hasn't gotten it. According to him, life's gotten in the way. But he's been employed by this company, and this company has had on their website and on their LinkedIn profile, where they list all of their employees, they have included his CV, in his CV, that he has a bachelor's degree. So they really go after him hard on his reliability, his honesty, and whether or not we can really believe what he says about so many other things. So he pretty much gets demolished. The unfortunate part about it is that much of, or at least part of, what the next guy from Aperture, whose name is Dr. Weller, what he bases his calculations on and his findings on, in part, come from this Shannon Burgess. And so the underlying information is suspect. So now we've had Welcher on the stand all day yesterday and all day today. So all day today was, now they started late. They started an hour late. Robert Alessi was, yeah, that's right. He confused. Thank you, Juliana, for reminding me. Shannon Burgess confused bits and bytes. And so some of his conclusions were wrong because he thought there ought to be more data than there was, because he didn't understand that bits are much smaller than bytes. So his underlying data is a real problem, and his underlying investigation is a real problem. So now we have this Welcher on the stand, and so Brennan questioned him most of the day yesterday, and then Alessi started cross-examination a little bit last night and then today. So they started late. It started an hour late, ended at 4:00, and Alessi said he was less than halfway through his cross-examination of this guy. And Welcher has been consistently evasive and difficult and kind of glib and snappy. And I don't think it's going well for the Commonwealth. To tell you the truth, I hope that Brennan sits down and has a little come to Jesus meeting with this guy, and he comes back with a better attitude tomorrow, because right now he's killing the state's case. He's just snappy and defensive and kind of condescending, and at one point, Alessi asked if something was possible, and he said, "Well, it's possible that we could shoot that Lexus into space. Anything's possible." So, I mean, he's really not doing a great job for the Commonwealth. And we have seen the ARCA experts. The ARCA experts are the folks who were initially hired by the FBI to do reconstruction, and then later hired by the defense in this trial. And they are a cut above this Welcher guy, and they are super professional and very good at testifying, very practiced. And so I think with how poorly this cross has gone for Welcher, I think odds are that the first thing they're going to do is call the ARCA experts. Once they start their case in chief, the defense does. I think the first thing they're going to do is call the ARCA experts so that Welcher's still fresh in the jury's mind and they can do a comparison of these two, because there really is no comparison between them. Now, I don't know about, I'm not a science wonk, so it may very well be that Welcher's calculations, his science is reliable, but there's not going to be any way to know that until we get the ARCA experts on. He did some what I would think of as unusual testing and experiments. For one thing, he used himself, because he's about the same size and stature as John O'Keefe. He literally went out and found the exact same shirt, hoodie, and jeans and tennis shoes that John O'Keefe was wearing that night, which was a little strange. And then he did a bunch of testing. They actually bought a Lexus, the same as the model Karen Reed's car, and and used it for testing. So what he said was, one of the things he did was he took what he called grease paint, so paint that doesn't dry, this bright blue substance. And he then simulated being hit by the car at 2 miles an hour, a glancing blow and rolling off of it, to illustrate that the injuries on John O'Keefe's arms could have been made by a jagged taillight. And, Alessi went back through it and said, but you're starting from a lot of assumptions. You're assuming that it was a glancing blow. You're assuming that it was, and really he kind of debunked this whole business, but it was very theatrical. And, at one point, he actually had the car back into him at 2 miles an hour. So, and then Alessi said, well, but that doesn't really simulate the fact that it appears that the Commonwealth's theory is that she backed up 87 feet and hit him at 24 miles an hour. And Welcher had to say, well, I wasn't going to let the car hit me at 20 miles an hour. So, I mean, I'm not really sure when you get down to it what exactly Welcher was trying to prove. He also said, we don't know where in that trajectory, if at all, we don't know where the car hit John O'Keefe. So we don't know if she was doing 4 miles an hour and just accelerating as she backed up, or whether she was 87 feet down and hit him going 24 miles an hour. There's so many unknowns. So Alessi did, toward the end of today, talk about the fact that that John O'Keefe really had no lower extremity injuries, no bruises, no broken bones. And I thought that there was a real tactical error committed, because the expert Welcher, in his presentation of his slides, his slide presentation, his slideshow, he brought up a different case that he had helped investigate in California that was a pedestrian fatality, and it was at the front of the car. And he was saying this guy had massive head injury, didn't have any broken bones. But when they put up the photos from the crash scene, including the body of the man who had died, there were massive he had broken ribs, there were massive abrasions all up and down his legs. I mean, it was clear that there had been a crash, um, and that this expert said was a front end crash, but in other ways was similar to what they speculate happened to John O'Keefe. So I think that this time, rather than um, going hard at the Karen Read was framed argument, they have gone hard at the there was no collision argument. And so that will be interesting to see once we get to the ARCA witnesses, who the internet now fondly calls the crash daddies. They're both eminently qualified scientists, and it doesn't hurt that they're nice looking young guys, and that they're that they're very good at testifying. They're very kind of at ease, relaxed in the way they testify. So we will wait to see what happens, but Alessi has said that he has at least probably tomorrow is only going to be a half day in trial, because there was a juror issue. A juror had some sort of an appointment, and they were going to end early tomorrow to accommodate the juror. So that's only going to go a half a day. I will be shocked if Alessi's done by Friday. So I know the judge would like him to be done by Friday, because I will say I'll be shocked if this witness is done by Friday. She said, we don't want to have to keep him here over the weekend, yada, yada. But I would be very surprised if he's not back on Monday. By the time Alessi finishes his cross, and then Brennan does redirect. So this really is the heart of the state's case. And I hate to say it, but my prediction is another hung jury. And I don't know. I hope I'm wrong. Now, we have heard that this jury is decidedly younger, that they're probably all maybe max 40. And there are a lot of people in the courtroom who have said that they think that might skew in Karen Read's favor, because they're not going to be as overwhelmed by the technical information, by the digital information. There may be more people who have a better grasp of the technology piece. So we will wait to see. So that is the end of my wrap up. I think we're ready to take some questions. So thank you, Jen. Hi, eat the food, Tina. I love that food's all in caps. Eat the food, Tina. How are you? If Karen Read is found innocent or another hung jury, can she be tried again? I don't believe the prosecution has proven their case again so far, but I don't know if she did it or not. Well, I don't believe that at this point the prosecution has proven their case. I'm with you. If she is found not guilty, she cannot be tried again. Double jeopardy attaches, and there is no way she can be tried again. If there is another hung jury, the state can opt to try her again. You have to ask yourself. So it came out today that this expert, Welcher, originally was paid or has billed about $44,000 in fees. He also, just before the trial started, signed a new contract for another $300,000. This guy, according to the internet, this guy, this company, Aperture, bought his crash reconstruction business, bought him out to the tune of in excess of $200 million. So he just got a big payday. Aperture has signed a contract with the Commonwealth for $300,000 in additional charges. So it does make you wonder. Now, we know that Karen Reed is currently has had to sell her home, liquidated her 401k, lost her job as a college professor, and is currently living with her parents. And she is somewhere around $5 million in debt. Most of it to her lawyers, who have said they don't expect to collect all of that. If she is found not guilty, I think that she has a colorable civil case against the Commonwealth. So she could recoup some of that from the Commonwealth. If there is another hung jury, I think, first of all, Michael Morrissey, who is the current district attorney, I think he's coming up for re-election. It could be another situation like in California with the Menendez brothers, where a new DA comes in and completely changes the game. And I think that there are enough people who are really fed up with the way this case has been handled from the beginning that I'm not sure that Michael Morrissey can get reelected. So that's also a possibility if we get another hung jury. It will be up to the DA to decide whether to bring the charges for a third time. Now, my understanding is there was a case in Massachusetts where it was 4 tries at a trial with a hung jury. But there does come a point when it becomes harassment and malicious prosecution. And so I think if there is another hung jury, the prosecution needs to take a long, hard look, because they have also paid Hank Brennan. Before this trial even started, they had already paid him $250,000. I suspect by the time the trial is over, he will have been paid close to $500,000. So I think the state, I think they're going to have to really take a long, hard look at how much more they can afford to pump into this particular defendant. Regardless, I think Karen Reed's life is changed forever. I don't know how you recover. You certainly don't necessarily recover financially. I mean, in the Vallow case, the only one we've seen that has really recovered is Brandon Budro, and that was because Melanie's attorneys defamed him and ended up having to pay him $12 million for defamation suit. So, which if it had gone to trial, they probably would have ended up paying a lot more. They settled for $12 million. So, we'll have to see. Like I say, if Morrissey gets voted out, I mean, it's a new day, and we can only hope that a new prosecutor would take a different view of the case than the current one. So, great questions, guys. Yes, Susie. And Lori's still trying to get rid of the judge. Yep. And she's still got appeals in Idaho, and the beat will go on for a long time with her. I don't think she's going to make any headway getting rid of this judge. He's been eminently patient, and I don't, as long as he's determined to stay on the case and not cry, "Uncle, I can't take anymore," I think she's stuck with this judge. Um, so we'll see. I think she's setting up to be convicted once again on the charges for Brandon. And I hope at that point the family in total will begin to see the end of the tunnel. For so long, I think both families, including Lori's family, have looked at the light and realized it was an oncoming train and not the light at the end of the tunnel. So I think I've seen some posts from Colby and some posts from Lori's sister Summer that they're beginning to feel like some closure. I'm certain that Kay Woodcock is beginning to get to the point where she's feeling a level of satisfaction that there's been some justice for Charles. And I think that once this trial is over and she is sentenced, then she can kind of fade into the prison system and continue to pursue her appeals as they all do. But so I sympathize with all of them. That I think the relief that this long journey is coming to an end is in sight for them. I mean, let's remember that this goes back to 2018 when Lori and Chad met, and it was 2019 September when the children disappeared and Charles Vallow died. So it's 6 years that they have been living this, and that's a long time to live with the level of uncertainty that comes with trial after trial after trial. So, good point, though. She is still trying to get rid of her judge. Hi, Roz. How much input could Lori's standby counsel have provided relative to all her motions? Is she completely on her own, or could her counsel have made suggestions regarding which to file? No, undoubtedly, they have made suggestions. Undoubtedly, they're working with her. I think sometimes if you read the motions, you can tell which ones her standby counsel said, yeah, that could be a good issue, and which ones she's just sort of punching at clouds. Certainly the motion, her attorneys would have advised her that you always make a motion for a new trial and to set aside the judgment. Now, will they tell her on what basis she should argue that? Maybe, but maybe not. She may have decided that herself. And certainly the motion for prosecutorial misconduct, I just don't think that any of her standby counsel would have recommended that. And I sure don't think that they would have recommended the motion regarding the Jeep. I mean, there's just no legal basis for it. And if you remember, she complained to the judge in the last hearing that he denies all her motions, and she said, well, then bring better motions. So he's not going to be overly persuaded by these most recent motions that don't have any basis in law. So the better argued ones, the ones that do seem to have potentially an issue that could be raised, I think are coming from her counsel, but they don't have any control over her. She can file as many motions as she wants. So, and we know that Lori thinks that she knows better than anybody else. So, what else you got for me? Hi, Beth. Didn't it feel like the Bryan Kohberger defense motion was more about not being ready than the Dateline stuff? Possibly. Um, yeah, what I would say is that they seized on the Dateline as ammunition to set it over to add to the fact that they're not ready. I mean, I think Ann Taylor has been very transparent about the fact that it's a huge undertaking to get a death penalty case ready for trial. Because not only do you have to try the guilt or innocence phase, but you have to do this huge mitigation case. So if he's convicted, then they have to put on the case for why his life should be spared. And what we know about that is that they look in every nook and cranny, every medical record, education record, employment history, military history, criminal history. They turn over every stone, not only for Bryan Kohberger, but for his family going back 3 generations. So that's a huge undertaking to go back to Bryan Kohberger's grandparents and their siblings to look at family history that far back. Um, it's a huge undertaking. And, sometimes the mitigation team is bigger than the litigation team, where you might have 2 or 3 lawyers who are on the litigation team for the guilt and innocence phase. You could have 5 or 6 mitigation specialists in the background, and they come from their mental health professionals, their education professionals, they come from a broad variety in criminal investigators. I once knew of a case. I wasn't directly involved, but knew of a case where the defendant was um, a, legal resident of the United States from Mexico. No, I take that back. He was from Central America. And they actually sent the mitigation team down to Central America with a woman who was both an investigator and a court interpreter, to go down there to conduct in that investigation, the piece of it in Central America. And it took them, I want to say, the better part of 3 weeks for this entire team to be down in Central America, being housed and fed and conducting their investigation into this guy's family in Central America. And that's not uncommon. It's not unusual at all. That mitigation team is probably going to spend weeks in in uh, Philadelphia, not in Philadelphia, in Pennsylvania, um, just researching his background. So it's a lot. And so I think Ann Taylor's been pretty transparent that she doesn't feel like she's going to be ready by the first part of August. However, I think that she kind of tacked on the issue of the Dateline leaks as a further argument for why the court should consider um, d- delaying the trial. So she just used that as additional ammunition. Now, I don't know which one's going to be more persuasive for the judge, or whether it's simply going to be a combination of both things. He's going to say, well, taking this as a whole, I can't see how we can go forward. Um, I mean, it's concerning. I'm sure that the people in Ada County are ready to rip their hair out because of the level of uncertainty. But the judge has not ruled yet on whether he's going to allow the continuance. So we'll wait to see. In the meantime, I'm sure that Ann Taylor and her team are scrambling like crazy, trying to get as much work done as possible before the trial date. So, But that's a good question. I think she's been pretty transparent about her level of preparation, and I think she just sort of tacked on the Dateline leak as additional ammo for why that it ought to be continued. So, good questions. Wouldn't Dateline have known better than to take this information and broadcast it? They are not bound by the gag order. Why wouldn't they? They, hi Polly, by the way. Um, why wouldn't they? They're in it for ratings and advertising money, and so there's no reason for them not to do it because they're not bound by the gag order. The gag order impacts people who are privy to the case, the prosecution, the defense, law enforcement, investigators, experts, all those people. But it doesn't cover third-party media. So I can see where they would say, you know, no skin off our nose if we broadcast this. It's not our bad. It's their bad for somebody leaking it. So yeah, I mean, is it ethical? That's a different question. But does it violate the gag order? It does not. So. Hello, Musicer 51. How does either the prosecution or defense benefit by leaking information to Dateline? I don't think either one of them do. But that does not mean that somebody on the outskirts of the case, law enforcement or somebody like that, didn't leak it. I don't think that it benefits either side to have these leaks happen because it could potentially cause it to be more difficult to seat a jury. However, people who leak could be doing it for completely reasons that they don't care about whether it makes it harder for him to get a fair trial or not. So there are definitely people who might say, oh, well, what I know about, I'm on the inside of the Kohberger case and I know this and that and the other about it, to make themselves feel or look important. And media outlets are going to take advantage of that. That's their business. So, yeah. Once again, we get to the question of just because it's legal doesn't mean it's ethical or vice versa. So, yep. Word up, hi Jackie, is that the defense is not going to call Proctor based on their request to add witnesses who were recipients of his nasty texts as a way to get the texts in without calling him. Thoughts? Well, I haven't seen this filing, so I'm not positive that this is what's going on. I know they filed a motion to amend their witness list to add some people, but it appeared that they were all document custodians. They were all records custodians. Now, there may be a separate amendment to the witness list that includes these people. I think it's possible not to have to call Proctor. So there's a couple of thoughts I've had about both Proctor and Brian Higgins. Now they were able to get Brian Higgins all those flirty text messages and all that stuff in through Yuri Buchanan. By doing that, they make Higgins look like a bad guy, and they don't have to give him the opportunity to be rehabilitated. He just looks like a bad guy, like a liar and like a cheater. And so uh, they've been able to do it with him. Maybe it's smart not to give Proctor an opportunity to be rehabilitated, because the prosecution is going to feel some level of obligation to protect their investigation by doing what they can to rehabilitate Proctor. If they do that, then he gets an opportunity to have his say. And maybe that doesn't work to their advantage as well. Maybe it's more advantageous for them to be able to paint him with the "he's a dirty, crooked, biased cop" paintbrush, and not ever allow him the opportunity to come in and defend himself. So, I mean, it's not altogether a bad strategy if the other people coming in are going to say, if you can get all those really reprehensible text messages from him in through the other people. So it might be a smart move. I think it was smart to do it with Higgins and not bring in Higgins, because then he doesn't get a chance to tell everybody, well, I'm a good guy. And, he comes off as a sort of philandering, lying, trying to instigate himself into John O'Keefe and Karen Reed's relationship. And so he doesn't get the opportunity to come in and rehabilitate his reputation. So might be smart strategy. Good question, though. Eat the food, Tina. In the Idaho 4 case, I keep hearing criticism of Ann Taylor for taking on another death penalty case. Since she works for the state, do you think she had a choice in the matter? This is a good question. So, not long ago, Idaho did some reorganization of their state public defender's office, and they asked Ann Taylor to head up the public defense office for the state. That's a big job. And she had the Kohberger case. There is another case in Eastern. See, the problem is that there are very few lawyers who are death penalty qualified. Back during Chad Daybell's case, when I looked it up, I think there were less than 20. There were 28 total, but not all of them were qualified to lead a death penalty case. Some of them were only qualified to second chair. So there are a limited number of them. If you then look at death penalty qualified lawyers in the more rural areas of Idaho, most of those death penalty qualified lawyers are in the Boise area. There are very few that are out in the rural areas. So Ann Taylor's got 2 strikes against her. So she took on Jeremy. I can't look it up right now, but it was a very difficult case. Guy was very mentally disturbed, kidnapped his young child, and they were later both found deceased. So that was one of no, I take that back. The baby was deceased. He was found naked in a sleeping bag on the road. And that is the other case that she took. Not public defenders do not always have a choice. they don't always have the ability to say, I've already got a death penalty case, I can't take that one. And death penalty cases, even within death penalty cases are very complex, but even within that category, some are more complex than others. Jeremy Best, thank you. And so, while Jeremy Best's case, it's hard to say if and when that case will ever go to trial. He was found to be incompetent, unable to aid and assist, and has been committed to the state hospital. And it is unknown at this point whether he will ever be restored to competency. It's one of those situations. If at all, it could be years. So on the one hand, yes, Ann Taylor has two death penalty cases. On the other hand, there's no telling when the Best case will ever come to trial, if at all. So, and you're right that public defenders don't always have a choice. I mean, when I was practicing, yes, I had the ability to say, whoa, turn off the spigot, because now I didn't do death penalty cases, but I did serious and complex felonies. And so I would get a stack of them, and I would have to say, wait a minute, I can't take another Measure 11 case. That's the mandatory sentencing scheme for violent crimes. And so it's a category in Oregon of violent crimes, robbery, rape, kidnapping, violent crimes. So, there's a tremendous amount of preparation that goes into those cases. And sometimes I would, our coordinator would call and say, can you take this case? And I would have to say, whoa, wait a minute, I already have 5 or 7 or, of these very serious cases. But ultimately, because you are with you serve the state and they have a contract, ultimately the state has the final word. And, there were times that my coordinator would just call back and say, listen, you've got to take this case. There's just nobody else to do it. And we have to take it. We can't turn cases down. That's not part of the way the state contract works. And I'm sure it's that same way in Idaho. The state contract is not going to allow the public defender to say, turn off the spigot, I have too many cases. So if it were an issue of there being a conflict of interest, or there was some other sort of thing keeping her from taking the case, that would be different. But if it's just simply, I have too many cases, the state's not very sympathetic to that, unfortunately. And that's why public defense is exhausting and backbreaking. Hi, Victoria. That was my idea. I think she wants more time, so she leaked the Dateline story. Maybe not her, but the defense. I don't know. I don't know Ann Taylor personally, but she has always struck me as as a straight shooter, and that would be very surprising. First of all, violating the court's gag order not only could have consequences for her, her career, her public defense contract, but it also could be an ethics violation with the bar. I mean, she could be putting her license to practice on the line, and I just don't know many lawyers that are going to do that for a continuance. Because the truth of the matter is, if the judge, it's incumbent on the lawyer to go to the judge and say, I need more time. I am not as prepared as I am comfortable with, or I am not as prepared as I would like to be. That's their job. If the judge says, I don't care. This case has been lingering on long enough and we're going to trial. Then the attorney has done everything that they are ethically required to do. If the outcome of the trial is that there are ineffective assistance challenges and those sorts of things, the attorney can say, I asked the court for more time because the judge was on notice that I felt that I was not prepared for trial, that I was not prepared to use my best efforts on behalf of our client. Yeah, it's kind of passing the buck, but it is, it does sort of relieve some of um, the responsibility from the defense attorney, because if the defense attorney's done everything they can to say, I need more time, and the judge has just said, we're going, then that's all that the attorney can do. It's gone over their head. So, but good questions. No lawyer likes to go to court unprepared. I always tell the story of a case was a Measure 11 case. So a violent crime was an armed robbery. And I got a call from one of the judge's assistants saying, can you take this Measure 11 case? And I said, okay, what's going on? So, well, this guy has run through 4 or 5 different attorneys, and every time he gets close to trial, and he won't waive speedy trial. So every time he gets close to trial, he fires his lawyer. And so the judge wants you to come in and represent this guy, but the judge is not going to continue the case. So I went in to talk to along with the prosecutor, went in to talk to the judge and said, look, you're asking me to get ready for a very complex case in 11 days. And the judge said, I understand that. And I don't blame you for being very uncomfortable about it, but I'm asking you to do your best to be ready to go to trial because I am not continuing the trial any further. And I said, well, I'm going to file all my motions. I'm going to make all my requests for extra time. And then that covers me when this guy comes back with, as he did, an appeal on ineffective assistance of counsel, which was where he was going all along. And they were denied based on the fact that he had continued to ask for new attorneys. So he got convicted, and the evidence was pretty overwhelming in favor of the state. So it wasn't a surprise that he got convicted. And sometimes you just have the situation where you get into that corner and you have to say, I just have to do my best, because I have to deal with the word from up above, and the judge has the authority to press you to trial even when you say you're not ready. So these are good questions tonight. Hi, Beth. Does mitigation take 2 years? Shouldn't they have started the minute the death penalty was on the table? Yes, and they probably did. But yes, I can see mitigation taking 2.5 years. Remember that they are going back 3 generations. You try and find your grandfather's military records from World War II or great grandfathers. Sometimes that takes that long, particularly when you're dealing with ancient records and government agencies. So it wouldn't surprise me. And yes, they will have started mitigation, but there were a lot of other things on their plate as well. So the mitigation team may have been sort of running in the background, but there have been a lot of other things on their plate as well, like the change of venue motion and getting all of the research done and all of the studies done in order to make the change of venue motion. And, I mean, there's so much to be done in a death penalty case. I mean, these people could be working 10 hours a day, 7 days a week and not get all the work done that they would like to have done in order to get ready for trial. It's a lot. And it's going to get nothing but worse. We're now hearing about terabytes of information, and in the Vallow case it was like 20 terabytes, and now in the Kohberger case they're talking about 60 terabytes, and you can't even imagine how many sheets of paper that is, how much data that is. So it just takes time. I mean, in the Delphi case, there was something like I don't know, 25 or 30,000 tips that came in from the public that had to be weeded through to see whether or not there was anything in them. And 90% of the time there's nothing in those tips. But then there's the 10% where there is something in the tips and it's important. So it's stuff that you can't just say, I'll get to that when I get to it. And so it's very labor intensive. Now, I will say Ann Taylor is one of those lawyers who likes to have her eyes on everything. And that's commendable. But in this day and age, I'm not sure it's possible. I'm not sure that it's actually possible for any single lawyer to be able to get through all of that information and be able to retain it and digest it. And the information overload is so huge. So, what else you got for me? I think we'll look towards wrapping it up. So, why don't you post any last questions? Hi, Marie. Hi, Lori. Do you have any thoughts as to why the CW Commonwealth has decided to prosecute Karen Read with such shoddy evidence and such suspicious circumstances? Well, I have thoughts. I'm not sure that they're any different than a lot of people. I think that police officers being involved is part of the issue. I think that it's possible that law enforcement did not dig as deeply as they would have otherwise because they may not have wanted to know the answer. I don't, sometimes not investigating something is because you don't want to know. And I think that may have been part of it. Part of it was sloppy. Part of it was good old boys, nobody's going to look at us. And I think part of it was, let's get a quick resolution to this. She'll cop a plea and it'll be resolved. I don't think they ever thought that Karen Read would fight back to the extent that she has. And she's an incredibly strong and resilient woman. To have gone through this not once but twice is hard to fathom. So I am with the person posted earlier and said, I just don't know. I think we will never know the true cause of John O'Keefe's death. And that is squarely at the feet of Canton Police Department and the Massachusetts State Police. That is squarely on them. Just things like bringing in the team, the search and rescue team to look for evidence in the front yard, rather than bringing in the evidence people to find the evidence. I mean, just crazy things like that. And that was all directed by Lieutenant Tully, who at the Canton Police Department and Proctor at the state level. I mean, that sort of shoddy investigation in some way, I think, was don't ask questions you don't want to know the answers to. So I think that was a big part of it. Was it a concerted effort to frame Karen Read? I don't know. Maybe on the part of one or two people, and it may very well have been that that the rest of the people just went along to get along. That's possible too. It doesn't take every person in the Canton Police Department being in on in on keeping quiet or in on let's let her take the rap in order for it to happen. It only has to be that the the leadership is in on it and the rest of them are like, yes sir, 3 bags full, and following orders. Let's remember that law enforcement agencies are very pseudo military. They have a very strict chain of command and a very strict leadership structure. And if the boss says this is the way we're going to do it, you say, aye, aye, sir, and you go about your business. And so it's not so baffling to me that that could be the case. That the higher ups told them, do this, do this, do this with the investigation. And they said, aye, aye, sir, and didn't ask questions. And not so much that there were people, a vast conspiracy of people. Could have been 2 or 3 people. They just needed to be the right 2 or 3 people within the leadership who had the power to say, nothing to see here, Sergeant, move on. So, and that wouldn't surprise me. So, last question. Anybody got one last question? If you have questions we don't get to answer, please post them in the comments. I do read them and I do answer questions. Although I must admit that I have not, I've been a little bit remiss in doing that the last couple of weeks. So, but let me know if you have questions. We are still working on squares for the origami crane quilt for the Woodcocks. So if you're interested in making a square, the directions are in the show notes if you want to do that. I'm working on some squares now, and I think we could still use a few more to finish it up. And oh yes, don't forget about CrimeCon 2025. The book has been nominated for an award, a Clue Award from CrimeCon, and so I will be there. It's in Denver this year. If you are at all interested in going and feel like the tickets are expensive, consider volunteering. They use a legion of volunteers at CrimeCon. And volunteering gets you a ticket and means that when you are not volunteering, you can attend the conference. And it's well worth putting a few hours in to volunteer. It gets bigger every year. Last year in Nashville, it was, I think the first year I went, it was 3,000 people or 5,000 people. Last year in Nashville, it was well over 15,000 people attending, and it's just getting bigger every year. So it's great fun. You get to see all your favorite creators down on Creator Row, podcasters and authors and YouTubers, you name it. So it's a lot of fun. If you're going to be in the Denver area or the Denver area is a convenient commute, I'd love to see you there in September. New address. If you need to mail me something, that's my my business P.O. box. And so Let us know if you have questions or other suggestions of cases that you would like us to cover. I did see a comment about whether or not I would be covering the 2 missing children. Um, I don't know, because I don't know how that case is going to develop. There you go, Jack and Lily Sullivan. First of all, that case is in Canada, isn't it? Am I wrong? Rachel, you tell me. Um, so Canadian system's a little bit different than ours. Um, you know, not not all yeah, not impossible to cover, but I'm sure there'll be a lot of Canadian creators that are covering it. So we'll wait to see how that all comes together and what comes of it. So yeah, I'm sure that Ian Runkle will be covering it once it goes, if there's a trial, because he's a law tuber and a Canadian law tuber. So, um, so with that, I'm going to say good night. Thanks for joining us tonight. It's always so good to see you. We had 114 in the chat. If you are not subscribed, please do so. It helps the algorithm, helps push content out, and definitely helps get the message out. Please, if you like our content, please share it with your friends. Let them know we're out there. We're not the biggest channel by any means, but we have such a great community, and I appreciate you all. I'm going to say goodnight. Thank you, Jen, as always, for being the best moderator ever. And we will see you soon. Good night.